Are you a parent navigating the complexities of co-parenting, family court, or even domestic violence? If you are looking for ways to help protect your children and build a strong and supportive community around you, then look no further. Gray Minds Think Alike is your go-to resource for everything related to the complexities of family life. Join us as we dive into thoughtful conversations with experts and explore practical tips and strategies for tackling the challenges of parenthood in the throes of adversity so that no parent feels alone and every child's safety is protected. Hello and welcome to Gray Minds Think Alike. Today we are talking with Seth Nelson, the founder and managing partner at NLG Divorce and Family Law. Based out of Tampa, they are known for their creative solutions to difficult problems in the realm of family law. Named the top divorce attorney on Tampa Magazine's top lawyers list in 2021, Seth focuses on his clients' interests and balances reasonable settlement options with zealous yet empathetic representation. I spoke with Seth about a year ago when I was on his podcast, How to Split a Toaster, because he said that he was getting many requests to speak with me about Greyson's Law. And of course, I was happy to do so. Welcome, Seth. It's so nice to see you again. And thank you so much for chatting with us.
Yeah, I'm Seth Nelson. First off, I'm so excited to be here. I'm just thrilled to talk to you. I was so loved having you on our show. You're one of our biggest downloads, and always happy to spread the word on an unhappy topic, but a way that it can turn positive.
Speaking of that, before we go into other topics, since we last spoke, what have you noticed about Greyson's Law and its application? Or what can you share about it as a lawyer?
Yeah, so I'm going to just talk in general terms, not about any specific case.
Yes.
Of course, lawyers always have to give our little qualifying statements. But first off, I hear the term Greyson's Law more and more, which is a good thing, because obviously the law is there to protect children. Nowhere have I ever seen, and you can correct me if I'm wrong, Allie, where it says Greyson's Law, right? Like in the statute. But the substance of what it means is throughout the statute, which is wonderful, which we all know is that you can look at a party's actions in its entirety, in its totality of the circumstance, and ultimately get protections for a child, even if that child is not directly being threatened. And that's the key. And so this has come up in cases from my colleagues I've heard about, from cases that I've talked about, whether it's been in domestic violence court or family court, because we know there's different courthouses there's different courtrooms in the courthouses, and therefore, depending on where you are, you might have to frame things a little bit differently based on the statutes that you're going.
So I'm just curious. So before Greyson's Law was enacted, you're telling me if you had a situation and you were in court and there was evidence of abuse towards a parent, that a judge would just say the same thing that happened with me, that person wasn't harming the child? Because to me, it seemed like common sense.
Yeah. And that's where, first off, the answer is yes to your question. That would be a common uphill battle that I would have to fight and have to make a causation argument. And what I mean by that is, yes, Judge, I appreciate that these actions are directed towards the mom, let's say. Dad's making the threatening behaviors, which impacts the child. Because if the action occurs or just having the threat happen, that changes the mom's perception, always looking over the shoulder, always being concerned, calling the police. There's an effect on the listener, which is the person that is suffering from the abuse and the threats. And I would have to make what's called a causation argument. So it's one step removed. It isn't directly towards the child. Now, in law school, in torts, which is harms, that's where you really learn about this concept of causation. So I'm going a long time ago for me, but it's one of those things where, okay, if a guy doesn't properly secure his boat next to a pier on a river and it breaks loose, and then it hits another boat, and then that boat sinks, and when that boat sinks, people get off the boat or are being picked up by others, but then there's an accident on that boat, and then a piece of the boat floats downriver and hits some. At what point does the causation stop? And that is just up to the trier of fact, which is either a jury or a judge, but in our cases, they were always in front of a judge. So I would have to make that kind of causation argument. Now, I don't have to make the causation argument. Now I get to say, look at this behavior. You're allowed to say, Judge, I'm worried about this. It's not directly towards the child, but you can consider it in protecting the child. And we've been successful, and I know other of my colleagues have been successful in doing that.
Yeah, it always boggles my mind to just know that the restraining order was granted for me, but he was okay to have a toddler. So like it just made zero sense to me, the mindset, because if any human being in my mind is hurting or harming or threatening anyone, even a dog, to me that's an issue.
That's right. And that's the difference, which unfortunately I have to explain to clients all the time, the difference between the real world and the legal world. And unfortunately, the legal world, as through your advocacy, takes a long time to change. And it always is behind the real world.
And why is that? Because we live in the real world.
Yeah, that's a great question. The real world moves much faster than our legislative process to change laws and through our court systems to change laws. Let's take an example. AI, artificial intelligence now, is moving at a dramatically rapid pace. And our lawmakers, and this isn't bashing them, but our lawmakers are usually not people who are tech industry guys or women and understand AI. And so just to get laws on the books about AI, by way of example, is going to take a long time. And by the time that happens, AI might have already changed, right?
Absolutely.
So that's an industry type focus. It's IT, which we all know technology moves at a rapid pace these days, but that's why it happens. And then I always call them the ivory tower. We have a statute that then goes to court, someone wins, someone loses, and then they appeal it. The appeal is only about one thing. Did the trial judge make a mistake? That's what an appeal is all about. And then the appellate court gets in their ivory tower. We give them a hard time about this. And they talk about what the law is or what it should be. And then they define the statute and they call their balls and strikes. Did they get it right or wrong, as Chief Justice Roberts stated during his confirmation hearing many years ago. But there's a lot of time that takes to get there. And our laws, and this is going to sound silly and obvious, are written down. And these appellate opinions are written down. And the English language isn't always clear. And you get clever lawyers that are going to argue one way or the other. And just if I can go on a little bit about not being clear, when we try to make things more clear, sometimes we make them more ambiguous. And here's what I mean. We know that there's children and adults. There's a vagueness in between when is a child and when is a child and adult. So then we come up in the English language and we say, we have adolescence. And we're like, look, we solved the vagueness, but we actually created another one. When is a child and when are they an adolescent? That's one vagueness. And when they go from an adolescent to being an adult, there's the second one. So we've solved one problem, but created two others.
Okay.
And that's just the form of language that clever lawyers are going to try to run a truck through.
Got you. I've seen it firsthand, so.
I know.
One more question about Greyson's Law, and then we'll move on to some other topics. Where have you seen some issues with it or pushback, or education-wise? Have judges maybe thrown it out because they didn't know about it, or what have you seen?
I haven't seen it where a judge, or I haven't heard of a judge throwing it out because they haven't known about it. Judges take things as they come to them. And so it's really a lawyer issue. Are the lawyers reading the statutes? Are the lawyers staying up to date on the latest changes in the law and then making the arguments? Okay, now, Allie, I am a self-confessed law nerd, and I'm just a short Jewish bald lawyer. And over winter break, I have done this for many years. I reread the statutes and I reread the rules because there's rules and statutes that I don't deal with on a daily basis. And therefore, it's just a good refresher. And I tend to do it over winter break because it's a little bit quieter.
Sure.
And it's one of those things that I'm like, okay, winter break time, this is what I do. Okay. I've been practicing law now for 20 years, family law for 18. I can't tell you I've read it every single year. Sometimes you're spending time with the kids and they're getting older and you want to do some fun stuff. But I will tell you, I don't think I've missed more than 2, maybe 3 years out of 18 where I've read the full statutes every single time.
I think as a family law lawyer, it should be that way. I know you have to probably do continued education, or CLEs they call it, just to learn about new stuff, because the power of our children are laying in the hands of someone representing us. And I think that's their ultimate duty.
Yes,
is
absolutely.
To be on top of.
That's right. And
everything.
That's why I focus on one area of law. It's hard enough to stay up to speed and run a practice and mentor young lawyers, but it's not, you can't count on a CLE, continuing legal education, to get you there. A lot of lawyers are like, oh my God, my CLE requirement's coming up. Let me go online and do the the courses. This is just grinding away. And if you don't love the grind, if you can't strap yourself in a chair over winter break and read the statute to make sure you don't miss anything, well, then reconsider what you're doing.
So with that said, you've been in family law for 18 years. Let's talk about that. And let's talk about what are maybe some common themes or occurrences you've seen in family law.
Yeah, so that's a great question. The key to family law, the keys, I should say, it's plural, are as follows in my mind. One, you got to know the law and be willing to continue to learn because it's constantly evolving and changing because of the appellate opinions that we set. But unlike other areas of law, and let me take criminal law, for example, criminal law is always looking backwards. Did a crime happen on a certain date or series of dates? But it's backwards looking. Family law, you look back to the history, for example, on a parenting plan and financials, and but it's constantly moving. I call it shifting sands because the facts, in quotes, the information that you might want to present to the court at a hearing, and it's not a fact until the judge says it's a fact. So that information you're presenting in court might be changing and evolving up or down, positive or negative for your case by your own client's actions, by the other client's actions, by third parties' actions, up and down, right up until the hearings, right up until trial, right up until the decision maker, the judge, has to make the decision. And along with those shifting sands, there's the emotional aspect of it. And there's what I call not the just emotional aspect, I call it the psychology of divorce. And I think the true practitioners understand the psychology of where their clients are and where they need, hopefully, to get to be in a healthy place to make proper informed decisions based on the law, not the real world. I wish it was they matched, but based on the law and lawyer helping them get there. So I say that I'm an attorney and counselor at law, and I take that very seriously. The attorney part, what I do in court, the drafting pleadings, making arguments, doing my research, knowing the law. The counselor at law is the psychology of it in my mind. And what I've seen over my years is the true practitioners, the really great lawyers that I respect, they get both sides of that. If you only get one, you're not going to get there.
Right. Now, I'm just curious, what happens if you have a client that you don't agree with their methods of either their divorce or handling the situation or children? Do you try to mitigate a problem, or how do you deal with a client that maybe might not be making the best choices?
It's a spectrum. So a client comes to me and they're making really bad choices. Okay. What I'm going to do is counsel them to make better choices. Because once again, this is shifting sands. And one, I think it's good for them. I think it's good for their kids. I think even if it's a non-kid case, if they're hiding money, I'm like, no, we're going to disclose it. They say, I'm not going to disclose it. I say, I'm out. But I give them kind of fair warning and I try to counsel them along the way. The attorney and counselor at law, that's part of my job. And if they want to continue to argue with me, if they want to continue not to take my advice, and it's easier for me now in my career than it might have been earlier in my career because I have a lot of work. When you're first starting out and you need every penny and every client, right? It's harder to let them go, but it's the right thing to do. So I would try to counsel them. But if they continue not to take my advice and counsel, and this is something if they're doing stuff unethically, I don't believe in, then I'm out. If they're just not taking my advice in settling their case, or if they're not taking my advice on how to give an offer, it's their decision to give the offer or not, right? Now, I'll certainly say to them, I don't know why you're paying me for my advice and counsel and then ignoring it. You're wasting your money. So those type of things, there's more leeway. But if it's unethical, if it's harmful to children, they're not changing their behaviors, they're not taking my advice and stuff, I'm out. And there's certain cases that I don't take because I just morally and professionally and personally don't believe in their stance that they're taking. And I'm not required to take those cases.
Well, that's great because that, like you said, I'm sure a lot of lawyers would just continue for the money, ultimately.
I hear that from colleagues. At least we're getting paid. And I don't ever look at it that way. I look at it as I'm doing my job. And if you do your job right, the money will come. Now, look, you got to stay on top of it. You got to make sure they're paying your retainers and fees. You don't want to get behind and be stuck holding the bag. But you got employees and team members counting on you, which are families counting on you. And So there's all that. But no, absolutely.
Now, like you said about rereading statutes and keeping updated and stuff, I'm just curious on a personal note. Do lawyers in general, family lawyers, know about domestic violence? Do they research about what that means and maybe coercive control and those types of behaviors?
Some don't. Some family law attorneys are like, I'm not going into domestic violence court. It's very rapid. If you file a petition for domestic violence injunction, that goes to the judge without the other side seeing it. If the judge enters the order, which is one of the choices, but let's say they do, there's a temporary injunction in place by under the statutes. It has to be heard within 14 days because you've taken away someone's rights without their ready constitutional law, due process, notice, and opportunity to be heard, which there's an exception, right? If someone files a petition that meets the standards, the court can take away someone else's rights and say, look, I took away your rights, but I'm going to hear you out within 14 days. So a lot of lawyers don't like it because it's so rushed and they don't think they can do a good job in 14 days. And it's very difficult fact scenarios and it's stressful and you got to clear everything off your plate to focus on that. And then your other cases get behind. So people are just like, I'm out. Talk to me about the divorce. I'll deal with it then. We handle domestic violence cases, both on people that have been accused and people that are saying, I've been the victim of domestic violence. But if it's someone, let's say, that's been accused, I'm going to look at it. And they're entitled to a good defense.
Sure. Yeah.
But I'm also going to give them advice on, we got to talk to a criminal defense attorney because anything you say in DVI court is going to come back in criminal. So sometimes I've represented people and I've gone in there and say, Judge, we're taking our Fifth Amendment, right? And then they go to the criminal law. Sometimes if I don't believe the allegations, and a lot of that is what I really think about it, then, I'll go defend them. That's my job. But if there's someone that obviously did it and they're not going to take my advice and counsel on I'm only going to hurt their case, not help them. And I'm not going to really get involved in those.
What about, let's just say my case in particular. I didn't know I was being abused. I thought I was just being tormented and ridiculed every single day.
That's part of the psychology of the divorce.
Right. Could you recognize that as a lawyer?
I think I have in the past. I'm not saying I've never missed one.
Sure, of course.
But that's part of really understanding what's happening. And I would really stress this to everyone listening is don't call your lawyer and say that your husband or wife is a narcissist. Please, for the love of God. One, we hear it every day. And two, I tell people that tell me that, I said, I will not use that term in court. Also, please don't call me and tell me that the other parent is alienating the child because we hear it every other day.
Yes.
And the judges hear it all the time. And it's not persuasive. It's not persuasive. What's persuasive is the behaviors. Get to the underlying behaviors and lead the judge. I'm not calling judges horses. I'm just mixing metaphors here.
Sure.
You lead the horse to water, but you don't have to make it drink. You don't have to ask the last question, isn't that alienation or isn't that abuse? The information, the behaviors will lead to that conclusion. Let the judge come to the conclusion.
You'll notice, though, that a narcissist's behaviors will lead you that way because there's a pattern.
There is a pattern. And when you point out the patterns, that it's regular reoccurring, Judge, like clockwork, right. Sometimes that's more persuasive. It's definitely more persuasive than using the term narcissist.
I know that's a slippery slope, especially because some people consider it a personality trait and some people think it's a disorder.
Right. But that's why you don't need to define it.
Right.
If you focus on the behaviors, I don't care what you call it, Judge. It's not good for kids. It's not good for this relationship. It's not good in this dissolution of marriage.
All right, let's shift topic. Let's talk about divorce, because that's probably one of the most common things that people contact you about, correct?
Yes.
Okay, so I guess how does one start the divorce process? If they know that whether it's one-sided or two-sided, right. What is the first thing that they should do?
It takes two people to get married, but only one to get divorced. So I hear you on that.
Interesting. Okay. So if one party doesn't want it, it will still happen?
It's still going to happen.
Right. Just take longer.
Yeah, potentially. And sometimes people stay connected in the litigation divorce process because they don't want it and they want to stay connected to their spouse. And the only thing still connecting them, especially if the children are growing or out of school or they don't have kids, is the divorce process. And you can only go as a lawyer as fast through the process as the slowest person or entity. So if the other side is dragging their feet and I have to file a motion to compel to get financial documents that they should have provided already, and then I have to set that for hearing, I'm going to be pushing that case back. It's going to take 30, 60, 90 days longer than it should. And that's 3 months. Maybe we can't get a trial date for another 6 months. So that's part of the problem. But back to your question originally, the first thing you do, you make a list of questions that you want to talk to a lawyer about. And when you call a lawyer, you should have in mind for your very first phone call, what are your goals for that conversation? What are your goals for that conversation? Some goals could be, I'm evaluating this lawyer on whether I want them to represent me. A goal could be, I want to understand what my rights and responsibilities are. People will just say rights. I also say and responsibilities. I want to understand the divorce process. I want to understand the basics of how a parenting plan works, how division of assets work, how does alimony work, how does child support work, how does attorney's fees and costs play into this. So you should really think about what you want answered from your lawyer. And the very first thing you should be saying is, here's my goal for the conversation. Does that match your goal to the lawyer?
That makes sense.
The second thing you should do in that conversation is ask the lawyer, here, after you tell them what your goals are, how much information about my situation do you need from me to be able to answer my questions? How much information do you need from me to be able to answer my questions? Because then you're going to let them lead the conversation on, okay, you want to do a parenting plan. I need to know how many kids you have. I need to know their ages. I need to know if there's any special needs. I need you to tell me the 3 worst things about your co-parent and the 3 best things about your co-parent. I need to know the 3 worst things you think you do as a parent, the 3 best things you think you do. And I want to know, I don't care whether it's true or not, what's the 3 worst things you think your co-parent would say about you? I'm not saying they're true, but what are they going to say? We all know what they're going to say.
Sure.
And maybe that gives me enough information to discuss a parenting plan and give you more than an outline, but put a little meat on that outline. Fill it out a little bit. And think of the word peace: parenting plan, equitable distribution, alimony, child support, everything else. PEACE. That's the outline. Okay.
There probably never is peace.
There never is. Hopefully you get there. But when you get to E, equitable distribution, you're going to want to know, just give me the basics. How does it work? It's the division of assets and debts. How do you do that? You start with identification, identifying everyone's assets, everyone's debts, whether it's individually, jointly held, or with a third party or entity. Because that's the only way you can hold things. You hold it by yourself with your spouse or with a third party or entity. And then you go to classification. Is it marital or non-marital? And how is that determined? Are there some assets that might have a component of both? Then you go to distribution. How do you decide who gets what? What about value? How do you determine value? Some things are easy. Bank statement. It tells you on the bank statement how much it is. Car, a little harder. House, a little harder. Closely held business, even harder. So you want to get a list of these basic facts, and then the lawyer should ask you, are there any closely held businesses? What do you do for work? Do you make any money? What do your assets look like? And then when you go to alimony, it's what do you do for work? How long? Are you stay-at-home mom? There's these basic questions. And the reason why I'm really focused on this and stressing this, that allows you to evaluate the lawyer. If you have a half-hour consult and you talk for 25 minutes, you cannot evaluate that lawyer in 5 minutes. You want the lawyer to be talking more, because otherwise you're just telling your story and they might agree with you and you'll be like, they're great. They should also tell you weaknesses in your case from what they've learned. Now, sometimes, and I say this, I say, here's my analysis in the first 6 minutes of our conversation, and they laugh because you can't really do a full analysis in 6 minutes, but that's what you want to do for your very first thing, and talk to that lawyer, but have a list ready. And I know you mentioned the toaster, so I don't know what season, but you can go on our website and we have an AI bot that only looks at our episodes. There's an episode out there about initial consultations, and listen to it. I think it'll be helpful for people.
Yeah, absolutely. I know that's a main source of conflict. What I'd say during the divorce process, what is the main conflict? Is it finances, money?
I think all those are symptoms. It's communication and control.
Communication and control.
That's usually what we're arguing about.
Because there's a lack of communication and one person wants more control.
There's a lack of communication usually on both sides, and maybe both people want control. But in the emotional aspects get in the way, and it all gets wrapped up into fear.
A lot of it's fear. What happens if, let's say, man worked their whole marriage for 20 years and they had 2 or 3 children who are going into college, but the wife was a stay-at-home mom? How do they divide their assets then?
The assets would be divided the same on whether or not they have kids or not, or whether or not they worked or not. Your question would go to alimony on what, if any, alimony will she receive based upon a 20-year marriage. What is her income? What is his income? Under Florida law, there's limitations on the percentage amount that you could get. It's a new law that just passed about 1.5 years ago now. Coming up on 2 years in July. So when it was enacted.
Can you repeat that? What is
yeah,
that
so
law?
there's a new, we're calling it a new alimony statute. So the old alimony statute in Florida, check your local jurisdiction. I know, Ali, people listen to your podcasts all over the country and beyond, but check your local jurisdiction. In Florida, there used to be something called permanent alimony, and lawyers use terms in the legal world that don't match the real world, because permanent didn't mean permanent. Permanent meant until someone remarried, if the recipient of the alimony remarried, if either party died, if the recipient was in a supportive relationship, they might modify it down if they're living with someone and they don't have as much need, or they become self-sufficient. So permanent didn't mean permanent. And also when the payor retired, they could go back and say, hey, I want to lower my alimony. I don't have the ability to pay. There's no more permanent alimony in new cases under Florida law.
Okay.
There's duration. There's an amount of time. And that amount of time is defined by the length of the marriage on the upper echelons. Less than 10 years, 3 to 10 years, half the length of the marriage. 10 to 20, 60% the length of the marriage. More than 20, 75% the length. So it's more defined now.
So it's an improvement, you think?
If you're the one receiving it, you're going to say it's not an improvement because I'm capped on the amount of time. If you're the one paying, you're going to say it's an improvement. I think whether you like the substance of it or not, clarity in the law is always better, because then there's less to fight about, which means there's less attorney's fees.
Okay, true. I just know that I have so many friends, people that call in or listen, that are going through divorce, and they just say it's taking years, and I just don't understand it. I'm just like, what is taking so long? So what does take so long?
Like I said earlier, you can only go as fast as the slowest person or entity. You want a lawyer that's going to move your case forward. You need someone focused on it. They should be updating you. You should access to anything filed in the court. You should have pretty much easy access to based on the case management systems. Sometimes it takes a long time if you have to get numerous business values, if you need a guardian ad litem or a social investigation, if there's forensic accountants, if there's outside people other than your lawyer, quote unquote experts, that need time to do their work, that could take 3, 6, 9 months, right? So that will extend it. And then maybe you don't get a trial date for another 6 months after that. But that's why you just got to be a dog on a bone and try to move it forward the best you can. And if your lawyer's not doing that, pick up the phone, call them and say, I don't understand where we are and where we're going and how long it will take to get there. I'd like to sit down with you and have a litigation plan and timeframes.
Makes sense. Say, what tips do you have or recommendations for couples with children in particular?
There's a lot, but a couple of the big ones. And let's just say these are two people that can get along for the moment. Okay. Their marriage didn't work, but they're not going to take it out on their kids. They're not going to make them pawns on a chessboard. And this is none of what I'm telling you is legal advice. Please check with your local jurisdiction lawyer that is licensed in your area. But I will tell you this, in a little kid's drawing of their family, and they can write words, basic words, you are never going to see the word husband, and you're never going to see the word wife. You're going to see mom, and you're going to see dad. Husband and wives get divorced. Parents and moms and dads do not. And I think words matter. So when you sit down to talk to your children, which is the most gut-wrenching, heartbreaking conversation you're ever going to have, and you're telling them that you're no longer going to live under the same roof, I would suggest going to a mental health counselor, maybe talking about having a script that you practice. And you sit them down, not in their bedroom where it's comfort, not in that what I always call the creepy room with the plastic that our grandparents all had on the couches. Do it where they play on their video games or PlayStations, because they're comfortable there, but they're also doing other things, right? They're not going to walk by and be like, that's where they told me. And then you have a script, and it basically goes something like this, but you got to make it right for your family. We want to talk to you because as mom and dad love you, and both of us together and individually will always love you. But as husband and wife, or wife and wife, or husband and husband, we have decided we think it's best that we no longer live in the same house or under the same roof. And we want to let you know that this is not going to negatively impact you, to the best that we can help you with that. And let's just say that, and listen, they're kids and they're humans, and they're going to want to know one thing: how does this impact me? How does this impact me? And we're going to say, we're going to try to limit how this negatively impacts you. And you got to make this all age appropriate. And you might, first question is, who's moving out, or where's my room? And we're going to say, we haven't decided that, but for now, we're all going to live in the same house. But I think me, Seth, dad, is going to move out. But I really want your guys' help in looking for a new place. And I know mom, or maybe mom just chimes in and says, yeah, and I'm going to be helping too, because we all want to make sure you got a nice house, right? We're not changing your school. You're still going to see your friends, right? So you try to make it about them and how their life is not going to change. We're both going to show up at your ball games. We're both going to be at recitals. We're both going to be at your plays at school, right? Yeah, some nights you'll be at mom's house, some nights you'll be at dad, but you'll always be able to call them. You'll always be able to text them, whatever the case may be. But have a script and make it about mom. And they say, are you getting a divorce? Yes, but that's just a legal process. That doesn't change how we love each other, and we're always going to be family. My friend Johnny's parents get divorced and they don't talk. Well, I don't know what's going on in their family, but I know about our family.
Now that all makes sense. How do you effectively come up with a parenting or time sharing plan?
We really try to make it unique to the family. And there's all different ways to quote unquote skin a cat. And there's no right or wrong in parenting plans. They're different. And there's a couple things to know about a parenting plan.
Okay.
One, I could write the best parenting plan ever. And if parents can't implement it, it's useless. Second, you could have no parenting plan. And I would tell you, there are millions of parents raising their children without parenting plans, and they're doing a great job. They're called married couples. Do you know any married couple that writes a parenting plan? No. It comes because if you get divorced, or if it's a paternity case, the court requires you to have a plan. That's the default. So the goal is to get a plan, put it on the shelf, and do what's best for your kids. Don't get wrapped up in the details of one night, overnight here, trade it back and forth. Your kids aren't pawns. It all comes out in the wash. If you can't have a long-term, meaningful, loving relationship with a child with 40% of the time, the other 10% to 50% is not going to help. But when you come up with it, look at the age of the child. Look at the parent's work schedule. You work at where they're going to be living in a geographical location. You look to see if there's finances to keep them in private school, or maybe you want to put them in private school. You look at the kids' extracurricular activities. Who's going to get them there? How's that going to work? What kind of things do you have to look at? I try to limit holiday time sharing because it messes up the regular schedule. And I think consistency and frameworks and boundaries are good for kids. But look, if you want to do it differently because it's your children, I'm not going to get in the way of that. I'm going to explain what the law is and what the court may or may not do, but they're your kids.
Now, how do you co-parent with the other parent if they're being difficult, if they're causing the conflict?
Yeah, that happens a lot, right?
Yes.
So there's a great book called Biff. It's about communication. So you guys should look it up, put it in the show notes. But it's brief, informative, firm, and friendly.
Okay.
Don't get into drama. You give brief responses in writing. You're informative. It's Johnny is running a fever. I'm going to schedule an appointment with the doctor, and I'm going to CC you on the email. I'm also going to call and we'll let you know exactly what they say. And I'll let you know immediately when the appointment is. I hope you can make it, right? And the fever is 103, right? Like, just please and thank you. Very nice. Please let me know if you need any other information. Happy to provide it. I'll keep you posted.
Now, piggybacking on that, I'm going to tell you what would have happened in my scenario.
Yeah, let's hear it.
So I would do that. I would say, Greyson's really sick. I have made an appointment, pediatrician, whatever. I would get a response back saying that I purposely made his doctor appointment during his work call or work meeting, and that I'm the one creating the conflict to alienate him, when in fact I made the first appointment I could because my child has 102 fever, and that's all I'm thinking about.
That's right. And so the response to that is, I'm sorry you feel that I've acted in that way. I took the first available appointment. I hope if you can't make it in person that you can call in and step out from your meeting. And I will forward you all of the notes from the appointment. You don't get into the back and forth. Just don't. But see, I was brief. I was informative what I did. I apologize that you think that I did that on purpose. I'm sorry that you feel I did that on purpose, which is kind of apology, not apology. It's really how they feel. It's not necessarily the best, but I took the first appointment available. Here's what I can do to get you involved. I hope you can make it. If not, if you can call in. If not, either way, I'll provide you with the documents, right? And I get that when people do the right thing, they're going to get this venom back. But one, it's the right thing to do, period. It's the right thing to do for your kid. It's the right thing to do for yourself. You know it. You just can't internalize what they're doing. And ultimately, and this is not why you do it, it looks good in court.
Right. Ultimately, with this went on for me in any kind of situation. Anything that I did, it was always thrown back and twisted, saying I did something in particular.
But these are just
Different
accusations.
motive.
And what happens when you're in the relationship, it hits you in your gut, right? So I have opposing parties saying negative things about me all the time. Do you think that impacts my life at all? No, because I expect them to say stuff like that, and I don't really care what they say. Right? There's your character and there's your reputation. I focus on my character because that's what I can control. Reputation is what other people think of you. So the other thing of that, to not let it hit you in the gut like that, is lower your expectations. Now, Ali, I have a question for you.
Sure.
You go to McDonald's and you're in the drive-thru and there's 2 cars ahead of you and you put your order in and it takes them a half hour to get to you. Are you upset?
Yes.
Yeah. Here's my question now. Why are you upset?
I'm hungry.
That's
and
right.
I have a crying child in the back that wants his Happy Meal.
All of that might be true, but I don't think that's the real reason you're upset. I think the real reason you're upset is because your expectations were not met.
Sure.
You expect
I went
to
through
get
a drive-through.
That's right. You expect to get through there in 5
Fast.
minutes fast. Okay. You're out at a fancy steak place and you sit down and they immediately come over and take your drink order. And then you bring your drinks and a few minutes later they come back and they take your order for your meal and your appetizer. And by the time the main course comes out, it's been 30 minutes. Are you upset?
Depends, but I get where you're going here, our expectations. But that is why we go through fast food drive-thrus for one thing and why we go to sit-down meals for others.
Right. That's right. So let's say it is a half hour. Different scenario, different expectations. So I tell my clients and I would tell people, when you talk to your former spouse or your spouse, ex-spouse to be, and you send them that nice message about, hey, unfortunately, our child is sick, and here's what I did. You should expect the venom back. Expect it. What's coming?
Yeah.
Because then you're not going to be upset. You're like, yeah, I know what's coming, but don't let it impact you.
Yeah, I had to learn to just let things roll off my shoulder, and I didn't reply most of the time unless it was
That's right.
logistics.
Yep.
But
Good.
everything just became a twist.
That it always is, but to your point, you've got to learn to expect it, evaluate it, move on.
But ultimately, I will say for people listening out there that these could be red flags because you never know what all of these behaviors would lead to, as in my situation.
You got to keep your guard up. Absolutely.
Now, I do want to talk about something that came into Florida law, like I think last year or the year before, the 50-50 law.
The presumption of 50-50.
Yeah, so before this law, I'm assuming that it was presumed to be 50-50, but it wasn't. Because I know when I went, Greyson's father wasn't even on the birth certificate. We weren't even living together. We weren't dating. And he still got 50-50.
Yeah.
So how is it different?
I have a view on this. Okay. So the old law, there were a set of factors, 20 factors, that the court considers when coming up with a parenting plan. 3 parts to a parenting plan. Parental responsibility, how decisions are made, time sharing, people think of that as custody and visitation, where does the child put their head on the pillow at night, and all the other stuff that goes along with raising kids, extracurriculars, right of first refusal, a bunch of other stuff, communication aspects. So the presumption of 50-50 now says that the court starts with presuming that 50-50 is going to be the time sharing schedule. Out of 14 days, 2 weeks, each parent is going to get 7 overnights. Okay.
So it wasn't like that prior? Because that's what they told me.
It was like that prior, but some jurisdictions and courts will be like, yeah, this judge is a 50-50 judge. You got to really work hard to change that. Others were like, the judge sometimes says 50-50, sometimes says not. So it depended where they started.
Okay.
So I'm going to get a little technical here to answer your question. And I think it's important, and I don't think this issue that I'm going to talk about and my technicalities in the law are going to be resolved for a couple of years once it goes through the appellate process.
Okay.
In the old law, to get a parenting plan that was more than 50-50, or the one that you wanted, whether it was 50-50 or not, doesn't matter. The one that you wanted, you had to prove to the judge by what's called a preponderance of the evidence that your parenting plan was best for the kid. Preponderance of the evidence is the lowest burden of proof we have in the law. So think of those scales of justice, and you prove your case just by a little bit. That's preponderance of the evidence. You should then win your case. Now, the next one is clear and convincing evidence. That's the next burden, which is more. And I don't want to put percentages, but to make it understandable, let's just say 51% is preponderance of the evidence, 70%, 75% maybe is clear and convincing evidence. And then the big one, which is criminal law, we all know, beyond a reasonable doubt. That's 95, 98%, right? So now you take that to the new law. The new law says there's a presumption of 50-50 timesharing, but you can get over that presumption by your burden to prove a preponderance of the evidence, the lowest standard, which in my mind, the law didn't really change. We always had to prove preponderance of the evidence. Now, I believe some judges are treating that presumption, preponderance of the evidence, as if it's beyond a reasonable doubt. And that's where I think it will have to get worked out in the appellate courts over the years to come.
So it's making it harder for families maybe where that 50-50 might not be the best situation.
In some cases, in front of some judges, it makes it harder because I believe those judges are misapplying the standard that I have to overcome to prove to them what's in the best interest of the child. So yes, I believe.
Why did they vote this in?
It was tied. This is politics now. Now you ask me a political question. There was for 10 years or more a big push to change the alimony statute that we talked about. And along with that, there were some legislatures that says, I'm only voting for it if you put in 50-50 timesharing. They did in the legislature exactly what I tell my clients not to do. I don't trade money for kids. They're separate issues.
No, politicians they run games. I'll scratch your back if you scratch mine.
And I get when you're going to court, you don't want to settle a parenting case and give that compromises away if you're not going to get, if you have to go to court anyway and argue about the money. So I get when people say we're settling everything or nothing. I encourage my clients to settle the most we can, and whatever's left, we'll let the judge decide.
Gotcha. All right, a lot of topics here in Florida, and it looks like there have been some positive and negative changes over the last 5 years. Do you see anything happening next?
There's always tweaks coming.
Okay.
I don't think there's any major shifts in Florida family law. I think there's a guardian ad litem statute that you're not allowed to use. Guardians can't use hearsay, which is an evidentiary issue. That's bubbling up to maybe change because what's the point if they can't talk to teachers and kids and report back to the court? So there's stuff like that, but not like a seismic change like we had with the alimony statute.
That's good to hear. I'm always interested in talking to my local top politicians, even just amending Greyson's law, because I feel like there are things that needed to be added back in that were originally in the first round that were cut out. And I do believe that training should be mandatory for judges and lawyers so that we can all do what's best for the children.
Allie, you get that passed, let me know. I'd love to teach that CA.
I will let you know.
Okay, keep me posted.
Yeah, definitely. And then I have a few others in my mind about when you disclose information for your parenting plan, like finances, that you should also have to disclose if there is a firearm in the home. Just yes or no. Just like anything else. Yep. Because I know that's something that would have helped me.
Absolutely.
Okay, so real quick, just to wrap up, do you have any last minute tips for someone looking to hire a family law attorney? What should they look for when they're doing their initial search?
So in that first interview, when you're interviewing that lawyer and talking to them, you should ask them for referrals.
Referrals. Okay.
If they're not willing to give you a referral, I don't think you should take them.
Yeah, I guess they do that on job interviews all the time. They ask for a referral.
Well, wait, I'm sorry. I want to be very clear.
Or testimonial?
No, I said it the wrong way. So I'm glad you said that. You should ask them to refer you to other lawyers. Sorry, I didn't say that properly. When you're talking to them, you should say, are there any other lawyers in our community that you respect that I should call.
Okay.
If the lawyer doesn't want to give you a name, I would not hire them.
Interesting.
And you should also tell them, hey, I'm talking to these lawyers. Will you please, in confidence, tell me what you think about them? And I do that. I ask, are you talking to any of the lawyers? And here's what I tell them, Allie. Sometimes they want to tell me, I said, I'm going to make you a deal. For every lawyer that I tell you, don't hire them, I'm in the business. I don't think they're going to do a good job for you. I will give you a name of another lawyer that I think will do a good job for you.
Okay. So you don't think that some lawyers will just purposely talk shit about someone just because they want the business?
I think they will. But if they don't give you the name of someone else to call,
I see.
That's the issue.
I gotcha.
You want a lawyer that doesn't need your case.
That makes sense.
Yep.
That means they're not going to be just in it for the money. They want to actually do what's right.
You would hope so.
You hope so. Yeah, I guess that's what we all hope for. All right. I really appreciate you speaking with us. I'm sure I could keep going and maybe we'll have a part 2 sometime
Sounds
in the near
great.
future. But thanks again. And just real quick, what counties do you service?
So I've had cases all over Florida.
Okay.
From Nassau County, which is like just north of Jacksonville, which people are like, there's a county up there. Yes, there is, all the way down south and across it. There's an expense to that, of course.
Right.
Zoom helps out. But if not, I usually have referrals. But we focus mainly in Hillsborough, Pinellas, Manatee. We're getting some cases in Sarasota, Pasco, Polk, Tampa Bay region, and growing up from there. I have cases in Orlando.
Okay, great.
Anything I can do to help. And we have, like you mentioned, How to Split a Toaster, a divorce podcast about saving your relationships. So if you're into podcasts, which I'm assuming you are if you're listening, check it out. If it's helpful, keep listening. If it's not, don't. It's really simple.
Listen to my episode on how to split a toaster, which I think we did, I don't know, it's probably been about 2 years now.
Yeah.
That's crazy.
It was great. We might have to have you back.
Yeah, absolutely. All right. I'll put all of your contact info in the show notes. Once again, thank you so much.
Yep. Thanks for having me.
All right. Talk soon. Bye.
Bye.
If there's someone that you want to hear from on this podcast, please feel free to send me an email. Or if you would like to be a guest, please reach out at Allie@graysonschoice.org.